Supreme Court found that the Justice Department had overstepped its authority when it classified bump stocks as illegal.
The President is directing the Attorney General and the Justice Department to ban gun modifications to turn a gun into an automatic weapon.
The last thing that we need here in Texas are red flag laws. We don't need any new laws.
The reality is that the laws that are on the books, you don't get to choose which ones people are going to follow.
There's no magic fix, no single law that will end gun violence once and for all.
If you think the Second Amendment is a settled, black and white piece of text, you're about to realize just how incredibly wrong you are. Right now, the United States is locked in a massive, high-stakes legal tug-of-war where the highest court in the land is rewriting the rules of engagement, and the average gun owner is caught dead in the middle. We are not talking about minor, slow-moving adjustments to local hunting laws. We are talking about absolute legal earthquakes that redefine who can be disarmed, what devices are considered highly illegal military-grade weapons, and what it actually means to be a law-abiding citizen in the eyes of the federal government. To make matters worse, this entire battlefield is being fought across two completely different, contradicting fronts. On one side, you have federal judges dismantling major gun restrictions, and on the other side, you have state legislatures scrambling to build legal traps to catch you the second you cross a border. If you do not understand the mechanics of this shift, you could easily find yourself facing a high-level felony charge for carrying a firearm that was perfectly legal in your own driveway just an hour prior. To understand how high the stakes have truly become, we have to look at the massive administrative showdown that took place on June 14, 2024, in the halls of the United States Supreme Court. The case was Garland v. Cargill, and it resulted in a stunning 6-3 decision that completely dismantled the federal ban on bump stocks. For years, the Bureau of Alcohol, Tobacco, Firearms, and Explosives had insisted that attaching a plastic slide-fire stock to an AR-15 magically converted it into a fully prohibited machine gun under the National Firearms Act of 1934. The penalty for possessing one was severe, carrying up to 10 years in a federal penitentiary. But the Supreme Court stepped in and issued a masterclass in strict statutory interpretation, ruling that the ATF had completely exceeded its authority and weaponized administrative definitions to bypass Congress. Writing for the majority, Justice Clarence Thomas went into exhaustive, mechanical detail to explain why a bump stock is not, and never has been, a machine gun under federal law. The core of the Cargill decision came down to a highly technical, high-stakes grammar lesson centered on the phrase, single function of the trigger. Under the federal definition established in 1934, a machine gun is any weapon that fires more than one shot automatically by a single function of the trigger. Justice Thomas used detailed technical diagrams and mechanical explanations to prove that when a shooter uses a bump stock, the physical trigger of the rifle must still reset and be depressed for every single shot fired. The device simply harnesses the physical recoil of the rifle to slide the firearm forward against a stationary finger, forcing the trigger to cycle at an extremely high rate of speed. Even though the gun is firing up to 800 rounds per minute, mimicking the terrifying rate of fire of an automatic weapon, the internal mechanism is still operating as a standard semi-automatic rifle. Every single shot requires a distinct physical movement of the trigger mechanism. This ruling sent shockwaves through the political establishment, prompting Justice Sonia Sotomayor to take the highly unusual step of reading her fiery dissent directly from the bench to emphasize its gravity. She argued that the majority was completely ignoring the clear intent of Congress, which was to restrict weapons that allow a shooter to unleash a continuous devastating hail of bullets with a single initial action. Sotomayor pointed out that to the average person standing in front of a rifle firing at near automatic speeds, the internal mechanics of a resetting trigger do not make a bit of difference. However, the majority stood firm on the principle that if a law is poorly written or outdated, it is the job of Congress to pass a new law, not the job of an executive agency like the ATF to rewrite the English language to fit a modern political agenda. But just as gun rights advocates were celebrating the massive victory in the Cargill case, the Supreme Court turned around exactly 1 week later and dropped a completely different legal bomb that left the entire Second Amendment community in a state of absolute whiplash. On June 21, 2024, the court handed down an 8-1 decision in United States v. Rahimi, a case that many feared would completely dismantle the landmark Bruen decision of 2022. For 2 years, lower courts had been using the Bruen test, which requires any modern gun law to have a historical analog from the founding era, to systematically strike down federal gun restrictions left and right. The Fifth Circuit Court of Appeals had used this exact test to rule that a federal law disarming individuals subject to domestic violence restraining orders was completely unconstitutional because no such laws existed in 1791. The facts behind the Rahimi case were, to put it mildly, an absolute nightmare for Second Amendment lawyers trying to defend him. Zacky Rahimi was not a sympathetic, law-abiding citizen who made a minor administrative mistake. He was a highly dangerous individual who had assaulted his girlfriend in a parking lot, dragged her into a car, and threatened to shoot her if she told anyone. After a Texas state court issued a civil protective order against him, finding that he posed a credible threat of future violence, Rahimi completely ignored the order. Over the span of just 2 months, he participated in 5 separate shooting incidents, firing wild shots in public spaces, including shooting at a constable's vehicle and opening fire in a road rage incident. When police finally raided his home, they found a stash of illegal firearms, leading to his indictment under federal law. When the Supreme Court took the case, everyone knew they were looking for an exit ramp from the extreme, rigid interpretations of the Bruen test that lower courts had been applying. Chief Justice John Roberts, writing for the 8-justice majority, issued a major course correction that permanently altered the future of Second Amendment litigation. Roberts made it clear that the Bruen test does not require the government to find a historical twin or a dead ringer law from the late 18th century to justify a modern gun safety measure. The Second Amendment is not a law trapped in amber, meant to only apply to technologies and social dynamics that existed during the Revolutionary War. Instead, lower court judges must look for the underlying principles that guided our ancestors' regulatory traditions to justify disarming someone like Zacky Rahimi. The Supreme Court pointed to 2 historical legal traditions, surety laws and going armed laws. In early American history, if an individual posed a credible, documented threat of physical violence to a specific person or the community, they could be forced to post a peace bond or a surety to guarantee their good behavior. If they failed to do so, or if they continued to menace the public, they could be temporarily disarmed. The Supreme Court reasoned that the modern federal statute disarming domestic abusers subject to active restraining orders fits neatly within this historical tradition of preventing imminent targeted violence. The immediate fallout of the Rahimi decision has been a massive sigh of relief for gun safety advocates and a major tactical shift for prosecutors. The ruling successfully preserved the federal ban on possessing firearms while under a protective order, a law that statistical studies show reduces intimate partner homicides by nearly 30%. It also provided a crucial roadmap for lower courts, instructing them to search for historical principles rather than exact historical prototypes. This means that other critical regulations such as red flag laws, restrictions on possession by convicted felons, and bans on carrying firearms in sensitive places like schools and government buildings are now much more likely to survive constitutional challenges. However, the court was incredibly careful to draw a very strict boundary around this ruling, ensuring it did not give the government a blank check to disarm anyone they arbitrarily deem irresponsible. The majority explicitly rejected the federal government's broad argument that the Second Amendment only protects responsible citizens. The court clarified that the word responsible is far too vague and could easily be abused by hostile administrations to strip peaceful citizens of their constitutional rights over minor infractions or political disagreements. Instead, any disarmament must be temporary, must involve robust due process, and must be based on an explicit judicial finding that the individual poses a credible, active threat of physical violence to a specific person. This brings us to the fascinating legal paradox that has defined the post-2024 landscape. If you look at Cargill and Rahimi side by side, you see a Supreme Court that is playing a highly sophisticated game of constitutional chess. In Cargill, the court sent a clear message to federal agencies. You cannot creatively reinterpret old laws to ban popular firearms and accessories without explicit authorization from Congress. In Rahimi, the court sent an equally clear message to the Second Amendment community. The right to bear arms is not absolute, and we will allow common sense, historically grounded restrictions to disarm actively dangerous individuals. But while the Supreme Court is busy fine-tuning these complex legal frameworks, the real-world consequence for everyday gun owners is an absolute minefield. Because the federal government has rolled back major restrictions, including the ATF's sweeping 2026 administrative reforms that eliminated the fee for National Firearms Act tax stamps and dropped the travel permit requirements for short-barreled rifles. States have gone into an absolute panic. Progressive state governors look at the Supreme Court's decisions and the ATF's new deregulation priorities as a direct threat to public safety, and they are retaliating with unprecedented local restrictions. This state-level backlash has created a terrifying geographic divide across the country. In states like Virginia, Colorado, and Massachusetts, legislators have rushed to pass aggressive local bans on semi-automatic firearms, high-capacity magazines, and NFA items like suppressors and short-barreled rifles. Virginia's highly controversial House Bill 217, signed into law in May of 2026, placed a strict ban on the future sale and manufacture of modern sporting rifles while capping magazine capacities. This means that a firearm that is completely legal, registered, and encouraged under federal law is now treated as a severe criminal instrument the second you cross into Virginia territory. This local patchwork of laws has turned innocent interstate travel into a high-stakes gamble. If you are a law-abiding citizen living in a firearm-friendly state, you might decide to take advantage of the federal government's new $0 tax stamp policy to legally register a short-barreled rifle for home defense. Since the federal government no longer requires you to fill out a tedious Form 20 travel permit to cross state lines, you might pack your registered rifle into your vehicle for a road trip, completely unaware that you're driving straight into a legal trap. The second your tires cross the border into a hostile state, your federally compliant, legally registered firearm makes you an active felon, facing mandatory jail time under strict local laws that do not recognize federal registration. Many gun owners falsely believe that they are fully protected by the Federal Firearm Owners Protection Act of 1986. Under this federal law, you are technically allowed to transport unloaded, locked firearms through any state in the country as long as the firearm is legal in your starting destination and your final destination. But what many people do not realize is that hostile local jurisdictions have found highly aggressive ways to bypass these federal protections. Police officers in states like New Jersey, New York, and Massachusetts are notorious for arresting out-of-state travelers first, confiscating their expensive firearms, and forcing them to spend tens of thousands of dollars on criminal defense attorneys to argue their federal protections as an affirmative defense in a state court. This ongoing legislative war has made it clear that the battle over the Second Amendment is no longer just about constitutional theory. It is a highly localized war of attrition. The Supreme Court's decisions in Cargill and Rahimi have laid down the rules of engagement, but the battle is now being fought in county courts, state legislatures, and roadside traffic stops. As the federal government continues to strip away administrative barriers and lower the cost of NFA compliance, the pressure on state legislatures to pass restrictive, retaliatory laws is only going to increase, driving an even deeper wedge between different regions of the country. If you want to survive this shifting legal landscape without losing your rights, your property, or your freedom, you can no longer afford to be a passive observer. You have to actively research the specific local laws of every single state, county, and municipality you plan to travel through. You have to keep a close eye on active litigation, because a single county judge's injunction can completely change what is legal to carry on one side of a highway versus the other. The era of assuming that federal compliance equals safety is officially over, and in this new era of constitutional whiplash, staying highly informed is the only real armor you have left.